Hey all, I am going through a little synopsis provided by a colleague, Adriana De La Torre. She works for Tower Law Group, and she is really top notch on breaking down these federal district court cases and getting to the some of the salient points without making us, read 50 pages. So it's really fabulous. This one happens to be, I've done a few of these before after she's published them, and I got really behind because of just how busy it is here and just never being available when they get published. And then they scroll on by. But anyway, here's one that just was published by her today. She publishes these in the LinkedIn group that I manage. It's called Social Security Disability. It's a closed group. It's very large. It's 3,400 people. And it's not just practitioners. It's not just lawyers and non-attorney reps. That group is comprised of retired ALJs, current staff at SSA and DDSs across the country, vocational experts if they provide services to the SSA, or sometimes when they provide private services on the claimant side. I know we have some of those great folks in there as well. Okay, so it is a big group. I mean, I don't own it. Someone else owns it. I'm just the manager since, I don't know, over 10 years, I guess. So here we go. And it has grown a lot. But she is probably a newer person in there, but she's fabulous. So this was a 10th Circuit case. It's TS. Those are the initials of the person that filed on behalf of a child. So we would say it's SSI, this case. So it's TS versus Commissioner of Social Security. TS filed for disability benefits for child, I'm just going to call him RS, in August of 16, claiming a disability since birth. The agency, so this would be down below, has a 3-step process for determining child disability. It confirms first that the child does not engage in substantial gainful activity. And I know you might laugh at that and say, a child, they don't work, they don't engage in substantial gainful activity. There are probably some rare exceptions, and that's why it's always like the first thing looked at, and it's usually a nothing burger. But imagine if you were a child star who was disabled and severely disabled. But there are child stars with severe disabilities, right? And they make a lot of money. They would not be eligible for SSI because it's SSI, it's a welfare program and it's needs-based, and they wouldn't meet that need. Okay. Now, the second criteria mentioned, of course, is they verify that it's a severe impairment. And those definitions of what makes something severe are in the on the SSA site amongst the various rules and regulations. And it's not a highly complicated endeavor. It's not very hard to find a severe impairment. That's very rarely going to be our struggle in a case. And the third thing mentioned, of course, of the three, assessing if the impairment meets or equals listed impairments or alternatively functionally equals them. Remember, children have a different definition of disabled than adults because ours all depends on our working ability. And obviously theirs, they're not expected to work. They don't have to work. And that is not the criteria upon which any disability for a child would be based. So after the initial denial, TS, who filed for RS, requested a hearing in July of 18. The ALJ denied benefits a few months later, and that decision in November of 18. Ultimately, the decision was remanded, and after a second hearing in November of 2020, the ALJ again denied benefits shortly thereafter in January of 2021. So remember, if it went to the Appeals Council after the first ALJ denial, the Appeals Council determined that the ALJ missed a step somewhere. Something was not right. They didn't make a judgment as to whether the child was legally disabled. They simply said the judge forgot to do something or missed a step or some other way of doing a legal misstep that had to be redone. So the case got remanded for another hearing with the same judge, which is typical. And I know that bothers people, understandably so. The ALJ found that the child had 8 severe impairments, including ADHD, autism, and Ehlers-Danlos syndrome. But the ALJ concluded that these did not meet or equal the listed impairments. That probably has to do with the degree of severity of those severe impairments. With no exceptions filed, the Appeals Council did not assume jurisdiction, making the January 2021 decision final, and the district court affirmed this decision. TS appealed, arguing the ALJ misjudged the medical opinion of the treating physician. The court reviewed the ruling de novo, checking if the ALJ's findings were supported by substantial evidence and the correct legal standards. So remember, the court is going to relook at it, but not really insert their judgments. The only judgment that they will relook at is if the ALJ's findings are supported by substantial evidence, not whether the court itself would have held the same. Okay. And of course, whether he again followed the correct legal standards to get to that ultimate determination or decision on that particular finding. The court noted, and this is the part that's kind of relevant, ALJs must, of course, explain the weight given to medical opinions, prioritizing well-supported and consistent opinions. Now, remember, this court upheld the ALJ's denial, but it points out that the ALJs must explain the weight given to medical opinions and must prioritize well-supported and consistent opinions. So a non-well-supported opinion, and by that could be one that has no evidence in the treatment records that even suggests what the doctor is now opining about. So it's kind of pulled out of thin air. And then the other thing is consistent opinions. Are they consistent with, if there is medical evidence in the medical records about the particular topic, is his opinion about it consistent with those records? You know, if he says, can't, you know, I'm just going to give an example here, can't walk more than 10 feet, but all the medical records indicate that the child walks down the hall and it's 50 yards and, you know, and that is not this case. I didn't even read this case. I'm just telling you, I'm explaining to you what we would mean by consistent. That would be inconsistent. Of course, there could be other reasons for that. It could be sometimes the child can, sometimes they can't. It could be one of those waxing and waning things. That's a whole nother possibility, but that's not what's being expressed here. So the treating doctor had opined that the child, RS, had extreme and marked limitations in several domains, and there's domains that they look at that are pertinent to a child's functioning as a child. Different again from the adults, right? But the ALJ found his opinion was inconsistent with the other evidence and gave it little weight as a result. The court now, the one that's being reported through this opinion, found the ALJ's rationale specific, so not vague, which we do see a lot of, and supported by substantial evidence, leading that 10th Circuit Court to uphold the district court's judgment affirming the ALJ's decision. So it all boils down to, again, this concept of, you know, I hear a lot, well, my doctor wrote a letter and said XYZ, and they think it's going to be inclusive for the fact finder, whether it's an adjudicator or an ALJ, and it's just not the case. The whole criteria, if you will, or concept that the opinion must be well supported and consistent with the other evidence, including his own records. So well supported by his own records, and they used to say not inconsistent with the other records in the file that has been submitted on behalf of the claimant, in this case, the child. So this draws me back to, and I think there's a video on it, when people want to send letters to their doctor, and I'm always like, no, you don't just do that willy-nilly. It's a bad idea. To me, it's more of a painstaking chore, and very helpful when you have a doctor that's willing to entertain the idea of providing additional information that he's keeping close to the vest about his patient, even though his patient wants it. Don't get me started on those that won't. Whole nother thing. But if you ask your doctor to, can you write a letter and tell him how, disabled I am, and I'm, I can't barely walk, and, I need help walking, and blah, blah. And he does, because he might very well see that you have trouble walking into his office and this and that. But if that's not ever expressed in his records all these years, there's no support. His opinion is not well supported by himself, by his own records. And this is where the whole problem comes in about the medical profession's really, really incompetent, sorry guys, medical record recording on behalf of patients. It seems like we're dreaming, it's like such a factory where you have to go through 100 patients a day and there's no really proper recording. I feel like there's definite ways to improve that, but they're not doing it, and these computerized systems, which can be so helpful in so many ways, are slightly abused. They're being, and this is probably happening before too, cut and pasted histories so that what's going on today is not reflected, but what was going on 3 years ago is kind of put in as today's. What patients say is going on with them, or the visuals are not being really recorded. So that's a really big mountain to climb in terms of getting that whole construct changed. I don't know if it will be or when. It's not in my pay lane to do it. I just throw out there that there's a problem. But it is not a bad idea, I think. And this is for new reps, if you're starting to do this and you want to try to get medical source statements from your clients treating providers, which is a great endeavor. I do it a lot. Go through those medical records and find out exactly where and when that doctor is saying something that you would want it to be expressed more in-depthly whether you have interrogatories in chart form or if you're asking for a narrative letter. Because if you can ask about something that he does say, and then he can expound on it. So even if it looks a little glossy in there, it can be really prickly once he opines on it directly, because now he's asked to be more specific. That might be something to consider doing. I gotta say, I never send out a medical source questionnaire that is generic off the internet. I know a lot of people are grabbing those 10-page monolithic things that cover all body parts. And it's what the SSA doctors might go through. But you're gonna get a lot of not disabled answers on that. And your doctor doesn't want to spend the time doing them. That's why probably 5% or less of doctors are willing to do it. If you narrowly tailor those questions for that treating doctor's opinion, you can pick the ones that are evidenced in the record and that are material to the case. If, having a broken pinky finger that doesn't work is not going to make a winning case, then why even bother asking the doctor about that? Go to the things that, you have to know about RFCs and vocational profiles, and you have to know a bit about the 12,000 occupations out there, or at least what makes for light, medium, heavy, and all that, to be able to do this and know what you should pick out. But I think that would be a better solution to get a medical source opinion that can be better accepted by an adjudicator or a judge as being worthy of more weights. And also you're going to have a better chance of getting your doctor to fill it out. It's 1 page. Maybe, 8 questions on it, 10 questions. We go through struggles to try to get it in a way that is going to be palatable for a doctor to take the time to do, but still give us the actual details that make a difference. And because you weed out all the ones that don't make a difference, it's really not impossible to put it in 1 page. Sometimes it's half a page. It's like 2 questions that are really important, Anyway. All right, that was a really a really good opinion, I think, and really, I thank Adriana for sharing that. It's 10th Circuit, but honestly, a lot of these will apply to everywhere else because they're all trying to go within the construct of the whole SSA system and the rules therein. It's a good one. It just drives home, what I'm just discussing here at the end. So anyway, I hope you're all having a great week. I will talk to you next time. Bye now.